Does a surviving spouse get everything if there's no will? Imagine losing a loved one and wondering what happens to their estate. If they didn't leave a will, the laws that decide inheritance come into play. These laws are called intestate succession laws. They tell us how the estate is divided among surviving family members. Whether the surviving spouse gets everything depends on the kind of property involved and who else is still alive. In states that follow community property rules, assets acquired during the marriage are usually called community property. If the spouse dies without a will, the surviving spouse generally inherits all community property. This means assets earned or bought together during the marriage pass directly to them. But separate property, which includes things owned before marriage or received as gifts or inheritance, is a different story. If there are no children, parents, siblings, or other heirs, the surviving spouse often inherits all the separate property too. But if there are children or other descendants, the estate gets divided. For example, if there is one child, the spouse might get half of the separate property, and the child gets the other half. If there are multiple children, the spouse's share might be smaller, like 1/3, with the rest split among the children. In states that are not community property states, the rules can vary. The surviving spouse might only get part of the estate, especially if children are involved. Sometimes the spouse inherits everything if there are no children, but if children are present, their share could be limited. Jointly owned property with rights of survivorship, like joint tenancy or tenancy by the entirety, usually passes directly to the surviving spouse outside of probate. This means it doesn't go through the estate process at all. Relying solely on intestate laws can be tricky. These laws follow fixed rules based on family relationships, not personal wishes. So, the surviving spouse might not get everything they expect if there are other heirs or specific types of property involved. To avoid surprises, it's a good idea to have a will or trust. These legal documents let you decide exactly how your assets are divided. Without them, the law makes those decisions for you, which might not match your wishes. Planning ahead can protect your spouse and ensure your estate is distributed the way you want.